Bis In Idem, General Comment Number 32, 2007, of Human Rights Committee. 54. Article 14, Paragraph 7 of the Covenant, providing that no one shall be liable to be tried or punished again for an offense of which they have already been finally convicted or acquitted in accordance with the law and penal procedure of each country. Embodies the principle of bis in idem. This provision prohibits bringing a person, once convicted or acquitted of a certain offense, either before the same court again or before another tribunal again for the same offense. Thus, for instance, someone acquitted by a civilian court cannot be tried again for the same offense by a military or special tribunal. Article 14, Paragraph 7 does not prohibit retrial of a person convicted in absentia who requests it, but applies to the second conviction. 55. Repeated punishment of conscientious objectors for not having obeyed a renewed order to serve in the military may amount to punishment for the same crime if such subsequent refusal is based on the same constant resolve grounded in reasons of conscience. 56. The prohibition of Article 14, Paragraph 7, is not at issue if a higher court quashes a conviction and orders a retrial. Furthermore, it does not prohibit the resumption of a criminal trial justified by exceptional circumstances, such as the discovery of evidence which was not available or known at the time of the acquittal. 57. This guarantee applies to criminal offenses only and not to disciplinary measures that do not amount to a sanction for a criminal offense within the meaning of Article 14 of the Covenant. Furthermore, it does not guarantee bis in idem with respect to the national jurisdictions of two or more states. This understanding should not, however, undermine efforts by states to prevent retrial for the same criminal offense through international conventions.